Well, hello there, and welcome to the Employment Law Show once again. I'm John Scholes. He is Lior Samfiru. We have got a lot of ground to cover over the next 30 minutes, so tuck in and stay tuned, and we'll get to all of it. What you need to know about wrongful dismissal, that in just a little bit will be our main topic for the show today. And we'll get to some phone calls from our long-running radio shows across the country. Pretty much, Lior and I on air, and a bunch of the other lawyers at the firm as well. Employmentlawyer.ca. You want to go to the media tab and find a station near you where you can tune in weekly to that show. They're either 30 minutes or they're an hour long, and it's nice because you have the opportunity with each of those shows to call in and ask your questions. Those are the phone calls we like to play here on the TV show, so stick around for those. Some emails and lots of other good stuff on the way, including a reference and the use of pocketemploymentlawyer.ca. Lior's going to give you more details on that nifty website, which he put together a few years ago. Creative guy. But Lior, we get to all that in just a bit. Week that was, case of the day, whatever we're going to call it this week. What do you got, pal?
Hey, John, awesome to be here, of course, to talk about this such important topic, the topic that we all need to know about because we all have jobs. And if we don't have jobs, maybe we're looking for work, and maybe we just lost our jobs. Either way, we have to know, we have to understand what our rights are. We have rights. We have rights if we lost our job. We have rights if we've been mistreated at work, if we've been discriminated against. We have rights if our job changes, if we're not brought back from a leave, maternity or disability leave. All these rights we have, the law knows it. The law understands that sometimes things happen and you need to have protections. You need to have things to do. And on this show, we tell you how to respond if those bad situations happen in the workplace. You don't need to go and try to figure things out on yourself in Google and invariably get the wrong information. We'll tell you what you actually need to know, what the law is and how it protects you. Great employment laws. We'll talk about everything you need to know. And of course, this is a 30-minute show. We can only get to so much. Beyond the 30 minutes, easy to reach me, my team across Ontario, across BC, across Alberta. You simply go to employmentlawyer.ca. All the contact information is there. We'll give you more contact information throughout the show. But now that we know that, let me tell you about a case that came across earlier this week. I spoke with a lady who had signed a fixed-term contract for 12 months with her employer. I guess it was going to be a maternity leave cover to work for 12 months. Well, 3 weeks into it, she gets called into a meeting and is being told, it's not working out. Unfortunately, we're going to let you go given that you're in your probationary period. Wish you all the best. Goodbye. No severance, nothing at all offered to her. Well, she calls me and she wants to know, well, am I owed anything? And I can see the hesitation in her voice. She's probably thinking, I'm probably not owed anything. I've been there for 3 weeks only. So I look at her employment agreement. The employment agreement says she's on probation, but it doesn't say anything else. It doesn't say that during the probationary period she could be let go without any compensation. It simply says you're on probation. Well, what does this all mean? It means because she's on a fixed-term contract, a 12-month contract, she was let go 3 weeks into it, her employer must pay her till the end of the contract for the remaining 12 months. That's over 11 months' pay that they have to give her. She's worked there for 3 weeks. Why is that? Well, the general rule with a fixed-term contract is if you're let go before that contract ends, your employer still has to pay you until the end of the contract, the balance of the contract, whether it's a 1-year contract, 5-year contract, or anything else. The other thing is this. Her employment agreement said she's on probation, but it didn't say anything else. It didn't say that during that period she can be let go without any compensation. If it said that, then yeah, she potentially could have been let go and not been owed anything. So there's a couple of very important lessons here. Number one, probation is not automatic. You're not really on probation unless you sign an employment agreement that gives the company the right specifically to let you go without any compensation for the first 3 months. Beyond that, of course, as I said, with a fixed-term contract, you could have significant entitlements if you're let go before that contract ends. In this case, she's owed over 11 months' pay. So if any of that sounds familiar, if any of that applies to you, you know what to do. Give me a call.
Not really a bad deal. Work for 3 weeks, get paid for 11, right at the beginning of the summer.
I'd like that, yeah.
No kidding. What could that have employer done? Well, first of all, we'll talk about the probation piece, but beyond the rest of the contract, what could that employer have done to avoid this 11 months of pay coming her way?
First thing, it didn't need to have a fixed-term contract. It could have hired her under a regular employment agreement with a termination clause in the employment agreement that allowed the company to let her go with minimal severance. It could have done that. Or it could have simply entered into a proper probationary clause. It didn't do either of those things. And now, as you said, the motion with the hand there, the hand means the money. They have to pay her the severance.
So why, as a business owner, would I ever enter into a fixed-term contract with an employee? Is there a benefit to me doing that as an employer?
Not really. No, even if you think I'm not going to need this person beyond 6 months or 12 months, first of all, you don't know. Things could happen. Maybe you need to terminate early. Maybe you want to extend them. So why have a fixed-term contract? You're better off having a regular indefinite agreement with a termination clause that gives you the ability to let someone go with minimal severance. So for employers, it doesn't really make sense. For an employee, if you have a fixed-term contract and you're let go before that contract ends, again, you could be owed until the end of that contract.
What's the worst, or I guess in her case, the best one you've ever seen?
So I had someone on a 5-year employment agreement that was let go a couple months into it. No, that was the reaction of the employer. John here is shaking his head. But in that situation, that employee, after working only a few months into a 5-month contract, was owed the balance of the contract over 4.5 years' pay. That's the way the law works. So if you're an employee and you're let go before that contract ends, make sure you give me a call. Your entitlements could surprise you.
I did mention phone calls. We like to play them back from our radio shows across the country on this show. By the way, to reach out to Lior anytime beyond the radio show or the TV, 1-855-821-5900, help@employmentlawyer.ca. But again, your phone calls make the radio shows that much better. And we play them back here, dissect them, talk about them a bit. So Lior will get the phone call number 1 right now.
I got let go from a job that I started about 7 months ago, and the severance that they gave me was essentially a paycheck and my vacation. I was kind of lured over under the premise of this great opportunity, but when I got to this job, it was very clear that that wasn't exactly what the job was. I was middle management.
The place that you were employed previously, how long were you employed with them?
4 years.
How old are you?
I'm 42.
That's arguably the most important piece of that is that the fact that she was induced, right? Or he was induced.
So for a short service employee, you actually may get credit for time you had with the previous company when it comes to severance if you were recruited away from that company. But let's break this into 2 pieces. First of all, let's assume this person is only a 7-month employee and was let go. Company lets him go. Even after 7 months, he's probably going to be owed several months severance. Okay, several months. That's how the law works when it comes to severance with short service employees. I want everyone to remember that. But this is even more interesting than that. He says he was not looking for a job. He was recruited from a company that he was at for 4 years, came to work for this company with the best of intentions, and then things didn't work out. Company let him go. So what does he get? Well, the law says if you're recruited away, you may get credit for those 4 years in this case that he had previously. So he actually may be a 4+ year employee and should be paid severance on that basis. So I'm going to go now to our severance calculator tool. You can find it, of course, at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Let's go to the severance calculator and let's see what this person should be getting given those 4 years that he had previously. So we see on the screen there, 42 years of age in a middle management role, been there 4 years, as I said. A company says 2 weeks is all you get because you really worked for 7 months. No, 8 to 9 months of severance is what this person gets. 8 to 9 months. So that's why it's so important, number one, to use the severance calculator, John, but also to remember that as a short service employee, you may have very significant entitlements.
That length of time that you worked for a previous employer before you were brought over or induced by your now employer, how far back does that, how long can you claim that? You know, once you've been with a new company for a year, 2 years, 3 years, 5 years, how long can you rely on that for?
So usually it's probably 3 years or so. In the first 3 years, you can kind of go back to that company you were recruited. Also, the longer you worked for that previous company, the longer potentially you have the time to carry that service forward. But the other lesson I'll mention, if you are recruited from another company, is watch out for that employment agreement with the new company. You don't want to sign something that gives the company the ability to terminate you very easily. Why would you agree to leave a secure job on that basis? Don't want to agree to something that puts you on probation. So watch out for that employment agreement.
Good stuff. Phone call number 1 there. We love it. Phone call number 2. Let's get into that right now as well.
My wife has worked for an employer for about 14 years, and she's been on maternity leave. The employer was purchased by a large corporation about a year or so ago. The days that she was working, they're no longer open. Because that day is not open, the clinic was offering alternate days, which she can't work, and they offered going to a different branch, and it would be a reduction of hours. What options or rights are available to her?
It's a lot of wrong there.
A lot of
wrong.
So the first thing is, why isn't her old shift or old hours available? Is it because they've made some big changes and this just doesn't exist anymore? Or is it because someone else is doing it? Well, if someone else is doing her job, too bad. They have to bring her back from maternity leave. They have to. It's not something that they should do. It's not a nice to have. They have to. So if right off the bat, if they're not bringing her when they could back into her old job, human rights violation, potentially employment standards violation, illegal. But let's give the company the benefit of the doubt for a second. Let's say they did a major restructuring. They're not picking on her. There's just the old job is not available. So they want to give her a different job, either different hours or in a different location. Well, this is where the concept of constructive dismissal comes out. If they're changing her terms of employment in a significant way, she may be able to consider that a termination and get severance. Same with you at home. If your hours, your pay, your work location are changed in a major way, you may be able to say, no, I'm not okay with that. I'm going to treat that as a termination and get my severance.
That is phone call number 2. We got one more on the other side of the break. And of course, as I mentioned off the top as well, what you need to know about wrongful dismissal, our main topic, is on the way as well. So stick around. Lots more of the Employment Law Show is coming right up. Stay with us. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back, Employment Law Show. Thank you so much for sticking around. I'm John Scholes. Lior Samfiru as well can be reached anytime. Help at employmentlawyer.ca through email. And that phone number, 1-855-821-5900. We'll get to our main topic for the half hour momentarily. But the phone calls from our radio shows across the country always come in threes. Number 3, the phone call is coming up right now. Listen up.
10 years at the business, making $300,000 plus. They changed the compensation plan, not plan, but work plan for where the business goes. I'm in the finance world, to reduce that income arbitrarily by 50% and more.
And when is this effective?
We got taken over by another company a month back. We just haven't signed anything, but didn't start rolling into like this month.
50%'s a big chunk.
Well, there's several ways a pay reduction can happen. There's the obvious way, hey, employee, we're reducing your pay. But there's other more subtle ways. Well, we're changing the structure of the pay, or how commissions are calculated, how bonuses are calculated. The bottom line is not how you get there. The bottom line is, does it affect your pay? An employer that makes significant changes to your pay, reduce your pay, generally if we're talking kind of 10%, 15% or more, that's a constructive dismissal. In this case, he's saying a 50, half of his pay is gone. Can't do that. That's a constructive dismissal, will always be a constructive dismissal, not something his employer is allowed to do. So he can accept this. Of course, the problem with accepting this, other than the obvious that he's making 50% less, is that now he's given the company the right to do it again. What a bad situation. They've reduced my pay by 50% and now they can do it again? Well, they can do it again because he accepts it. So the other option is not to accept it, to treat that as a termination, as a constructive dismissal, and get his severance. By the way, the severance that he's going to be owed is going to be calculated on his full compensation, on his pre-reduced compensation. So he could have significant entitlement. Same you. If your pay has been affected in a significant way, consider constructive dismissal, starting by calling me.
Yeah, we've talked about this, the phone calls similar to this in the past, Lior. And, someone says, oh, they're coming at me with a 10 or 15% pay reduction. They said it's temporary over the summer. Okay, maybe if you get it in writing, you'll take the hit. 50%, come on. That's a no-brainer. You just won't accept it.
Absolutely. I mean, there's really no way around it. You know what that means. You're making 50% less. It doesn't matter if you're making $40,000 or $300,000 like this person. It's a big, big deal. So don't accept that because, again, bad things can happen. It can't be the end of it because you let it happen that very first time.
Main topic, here we go. Wrongful dismissal, what you need to know about it. A wrongful dismissal does not refer to the reason for someone being fired, which in the language, they really got to call this something else moving forward. But yeah, wrongful, you think, okay, it's wrong. They can't do it for that reason.
Right. It suggests that the dismissal itself is wrong. Well, let's be very clear on this. When it comes to wrongful dismissal, it really has nothing to do with the reason you've been let go. And the reason for that is an employer can generally let you go at any time and for most reasons, as long as severance is paid. So if your employer lied to you about the reason, didn't give you a reason, let you go for a reason that didn't make sense, that's actually not a wrongful dismissal. Wrongful dismissal generally has nothing to do with the reason. A wrongful dismissal actually has to do with the severance, with the compensation that you're owed. So if you're let go without proper severance or you're less than your full severance, that is a wrongful dismissal. You've been wrongfully dismissed then. So that's why you hear me talk on this show, or if you call me on the phone, that's why you hear me talk often about severance, because from a legal standpoint, that's what the law looks at and what you're owed if you've been wrongfully dismissed.
The way to remember, I find, is just look at your severance offer and go, oh, that's wrong, because it's going to be wrong, the amount generally, right?
Good way to do it. 90% chance, John, that it's going to be wrong. It's just, it's almost always the case.
Yeah. Point number 2 is this, Lior. Termination for cause often results in a wrongful dismissal.
So most terminations is what we call terminations without cause. And what that means, you're not being let go because of something horrible that you do. It's you're let go because the company may want to make a different move or hire someone else or restructuring, cost cutting. But even though the termination itself may be perfectly legal, hey, if the company is restructuring, it's not illegal to let you go. You could still absolutely be wrongfully dismissed. In fact, there's a 90% chance that you've been wrongfully dismissed because most people, when they're let go, big company or small company, are offered a lot less severance than what they're actually owed, a lot less than what they're owed. So there's a really good chance. If you were let go, you're looking at that severance letter that you are actually staring right at a wrongful dismissal. So call me, use a severance calculator. You can find that at pocketemploymentlawyer.ca. And of course, don't sign off on that paper, because if you do, you may be unable to do anything else further.
Again, just to go over what we're talking about this week on the show, main topic, what you need to know about wrongful dismissal. Point number 3, employees have up to 2 years after initial date of termination to pursue that severance.
Well, why do I mention that? A few reasons. Number one is I don't want people to stress out, if you were let go, I have to deal with it today. You have 2 years. And oftentimes people watch this show and they realize, oh my gosh, I was let go a year and a half ago. I can still call Lior because I have 2 years to do so. So that's number one. You have that 2 years, so make sure you keep that in mind. But the other reason is with respect to severance deadlines. If you're let go, you're staring at that severance letter, you've been told in the letter, it says, well, you have to sign this by Friday. Wait a second, I just told you, you don't have to worry about Friday because you have 2 years. Your legal rights don't expire on Friday. You have 2 years to pursue them. And if you've been let go and have not been offered proper severance, you've been wrongfully dismissed. And you have 2 years to pursue those entitlements resulting from your wrongful dismissal. Don't fall for that severance deadline. It's a pressure tactic. That's all it is. Once you sign it, I can't help you. No one else can. So make sure you do the right thing and get advice before you sign.
We'll get to one more talking point on this topic here, Lior. It is this: you do not have to, nor should you handle a wrongful dismissal claim on your own.
You know, I struggle with this sometimes because people ask me, well, you told me I've been wrongfully dismissed, Lior, you told me I'm owed this much severance. Can I just deal with it on my own? And, you know, when I say no, it sounds a bit self-serving because I'm a lawyer, I want you to call me. But the reality is the likelihood of you being able to do it successfully on your own is very small. There's a few reasons for that. Number one is you may not even know how much to ask for, and sometimes people ask for the wrong amount. They lowball themselves, and they should have asked for more, and they accept less still. The company is not going to take you seriously. The company itself may not realize that they owe you more, so they're not going to listen to you. We want the company to speak to their lawyer so that they can get the proper advice. And they're not going to speak to their lawyer unless they hear from your lawyer. So as a practical matter, if you want to make sure you get everything that you're owed, to do it fast, to do it on good terms, yeah, you don't like me, call another employment lawyer, but you need to work with a professional.
And there you have it, a quick look at wrongful dismissal. For more details, again, you can go to pocketemploymentlawyer.ca. There is, of course, a section on it there you can read and go over on your own time. We have more of your questions on the way on the other side of the break, but I'll give you the number as we get into that break to reach Lior and his team. 1-855-821-5900 is how you do that. Help at employmentlawyer.ca, and more of the Employment Law Show is coming right up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. Here we go. It is terminationquestions.com. That's the website I wanted to mention as we get into our question here. You can go there anytime. It's anonymous. It's free. Lay your questions down there. Either Lior or a member of his team answers them. And sometime your question may appear on this show, like this one, which I'm about to read right now. Guys, have been employed at a chiropractor's clinic for almost 29 years. I'm 58 years old. The current owner has announced that he has sold the practice and will stay on for a short while under contract. Is the new owner obligated to keep me? If I'm not kept on, what am I owed?
So this happens often, not just with doctors' offices, other businesses where someone may be retiring or the business is sold. So let's talk a bit about that. So certainly when it comes to a new business taking over, a new owner taking over, the new owner is not obligated to keep the employees. It can decide to keep all of them, to keep none of them, to keep some of them. That is up to the new owner. What is important to remember is this. If as a result of a sale of a business, you lose your job, well, then it's a termination. You are owed severance. Now, if you continue working with a buyer, they generally inherit your service, which is a good thing because down the road, if you're let go, you should be getting severance based on your total years. But if you lose your job because of the sale of a business, you are owed severance the same as every other termination. So the short answer in this particular situation, severance must be paid. And of course, after 29 years, that's going to be a very significant amount. So I'm going to go back once more to our severance calculator tool. You find that, of course, online at pocketemploymentlawyer.ca. Click on the severance calculator, and you can use it anytime for free and completely anonymously. Let's do that right now for this scenario, and let's see what that gives us. So we know 58 years of age, 29 years of service in a clerical role, kind of the doctor's office. Well, we see that right there, that the severance is owed is 18 to 24 months. And John, it's probably much closer to 24 months. That's what's at stake here. Now, obviously, that doesn't happen if she continues working with the buyer. But if you're not continuing working, if you lose your job in a sale of a business situation, severance is owed. And of course, as I said, pocketemploymentlawyer.ca to find out just how much you're owed.
And the previous owner is on the hook for that, correct?
Correct.
Okay.
If you never work for the buyer doesn't have to pay you anything. Okay. If you never work for the buyer, if you end up working for the buyer, they inherit everything, all the obligations. Right. But if you never do, then the seller is the one that's obligated to pay you your severance.
You want to join Lior and his crew on their live stream? They do it all week long. You can do so Facebook, YouTube, LinkedIn, at ST Lawyers. At ST Lawyers is how you do that. Question for the week, Lior. My employer has asked me to submit my 2 weeks notice due to concerns about my performance. I'm unsure whether it's better to resign or wait for them to let me go, as I don't want to be let go for cause. What should I do? This happens all the time.
It's almost never a good idea to resign. The only reason the company would want this person to resign is so they can avoid paying severance. Now, the fact that maybe performance is not good does not mean that this person can be let go without severance. It's extremely difficult. I've said this before, to let someone go without severance. It's not enough to show that maybe the employee wasn't doing a great job. The employer would have to show that the employee almost went out of his or her way to do a bad job. Maybe then, if they were warned, etc., can they be let go without severance? So no. In this situation, even if performance is lacking, yeah, the employer may let the employee go, but then severance has to be paid. EI is owed. If you resign, you don't get severance, you don't get EI either. So the answer is no, employer, I'm not resigning. I'm going to continue working until or unless you, employer, Tell me that I'm no longer allowed to work unless you let me go. So no, I see this often. Employee, we expect your resignation letter in the morning. No, you're not going to do that. You're not going to give that resignation letter. You're not going to give the employer that gift of not having to pay you severance.
Plus, if you're told to do it, now it's no longer a resignation. You're getting canned.
That's another aspect to this. If you're told you better resign, then, well, it becomes a termination. Still better not to do that. You don't even want to go there. By the way, I'll make one last point. If, despite what I just said, you end up resigning because you feel that pressure, you feel that you have no choice, they threatened you into resigning, please, please, please do me this one favor. At least in your resignation letter, say so. Say that I'm resigning because you told me I had to. If you put that in the resignation letter, we may still be able to get you severance, but best advice, don't resign.
I think last point in this one before we move on is a lot of people, and I think this illustrates, a lot of people think there's this repository, there's this blacklist. Oh, I got fired. I'd rather resign. It looks more shiny and happy if I do that, right?
Yeah.
That's incorrect.
It's going to be some record that's going to be kept and it's going to be held against me. No, it doesn't work that way. There's no record that's kept against you. There's no reason why you would prefer to be let go than to resign. So don't do that. Don't be stressed by it. Get the entitlements that you're owed, including EI, which can pay you for a year. It's not going to hurt you in finding another job.
All right, trying to move on to our last segment of the show as we roll on. This is the employment law rapid fire, so strap in. We'll do it right now. Okay, it's time for the cardio portion of the show. Here we go, Lior. Number one, can you be put on an unpaid suspension by your employer?
No. You cannot. For most employees, of course, we're talking non-union employees, you cannot be put on an unpaid suspension. That is a constructive dismissal in many cases. Now, if your employment agreement specifically allows the company to suspend you without pay, that's rarely the case, then maybe they can do that. For most employees, suspension without pay, not legal.
Number two, are you permitted to take sick leave for longer than a few days?
The answer is absolutely yes. Your doctor decides for how long you can take your leave for. You may have already used your sick days, but that doesn't mean you're not going to be sick. You don't control that. You can take sick days, a disability leave. You can be off for as long as you need to, weeks, days, months, even years, if that's what you need to. So don't stress out over it. If you have a doctor's note, you can be off work.
We're talking the rapid fire questions for this week. Number three is this, Lior. Can you report incidents of bullying or harassment to your employer?
Well, forget about can. You should and you must, in fact, report these incidents to your employer. If you're being harassed, bullied, mistreated in the workplace, poisoned work environment, you should report it to your employer in writing, because I want it to be a record of it. Give the company the obligation to fix the issue. They have to. If they don't fix the issue, you come talk to me and I'll deal with it. But you want the company to be aware of what's happening and to have the opportunity to fix that problem.
Rapid fire number four, are you entitled to a raise, or should I say, is the employer entitled to give you a raise? Do they have to?
So in most cases, an employee is not legally owed a pay raise. Now, if your employment agreement says you will get this type of raise, of course, the employer has to give you what the employment agreement says. Beyond that, an employer is not legally obligated to provide a pay raise, not even a cost of living allowance. Now, of course, they should. But from a legal standpoint, a raise is up to the employer. Oftentimes you can negotiate that, but legally they're not required.
Number five, can you ask to be reinstated at a job after you've been let go?
So absolutely you can ask, but in terms of what the employer is obligated to do, they're not legally required to reinstate you if you've been let go. There's no legal mechanism to force your employer to reinstate you. The only mechanism that's available if you lost your job is to get you compensation, to force the company to pay you compensation. That could be 2 years' pay, can even be more in some situations. But generally speaking, in some cases, you can negotiate a reinstatement, but that's very unlikely and it cannot be forced.
Last one, not sure about the answer to this one. Can you pursue more compensation if you've already agreed to a severance package?
No. The answer is no. If you signed off on that severance letter, you're done. That's why you never sign it without speaking to me first.
Exactly. Rapid fire done for this week, and that is it for the show. Reach out to Lior now anytime you would like. Phone number first, always 1-855-821-5900. help@employmentlawyer.ca, and that website, right? pocketemploymentlawyer.ca. We'll catch you next time right here on the Employment Law Show.